Mediation in Italy in 2022. Very interesting developments. The length of civil process, like years according to Plato, is a child of poverty and abundance. Poverty of judges and abundance of lawyers. However, in spite of the analogy, the only thing methodological here are the times. Long, very long, biblical. This is the opening of an article published in 2021 about the huge length of civil trials in Italy. Italy is a country in Southern Europe. It covers an area of 300,000 square kilometers, has an estimated population of 60 million people. There are almost 9,000 judges and 242,000 lawyers. In 2009, there were almost 6 million pending civil litigation cases in the overall judicial system, the highest number ever reached. In 2010, compulsory civil and commercial mediation took off and came into force in 2011. Furious opposition by lawyers, benign neglect by judges. The main criticism was mediation does not belong to the Italian legal tradition. History teaches the opposite, because there are plenty of examples of the presence of mediation in the Italian legal and social history through the centuries. Italian compulsory civil mediation, Legislative Decree 28, was introduced in 2010, in force from 2011, revoked in October 2012, and reintroduced in September 2013 with some innovations. Among others, compulsory lawyers' assistance to the parties, the first information meeting free of charge, and the possibility for the parties to opt out of the proceeding. In the first information meeting, the notary explains the main features of the proceeding and asks the parties if they want to start the mediation. Parties can opt out for justified reason. If they opt in, the mediation starts. No longer compulsory, but voluntary. The mediation agreement is an automatically enforceable title if undersigned by the parties, the lawyers, and the mediator. Judges can order litigants to undergo mediation in all subjects related to alienable civil rights, or issue a solution proposal based on equity in all subjects related to alienable civil rights. Proposal which the parties are free to accept or refuse. In other words, not binding arbitration. In many cases, the judges blend the two options, a solution proposal and, if rejected, an order to mandatory mediation, ARB, then MED. Regretfully, the invited party waives the start of proceeding without significant reasons too many times. In addition, too often, the parties are not present themselves, but are represented by a lawyer, thus deeply undermining the effectiveness of mediation. The results show lights and shadows. In 2019, there were almost 3 million new proceedings filed in civil courts, 147,000 civil mediation proceedings, 20,824 mediation settlement agreement, or 0.7% of the new proceedings filed in courts, too little. Anyway, in the 2011-2019 period, there has been a decrease in civil court litigation, -4% per year, because of the economic crisis, a strong increase in mediation proceedings, plus 18% per year, and a strong increase in mediated settlement agreements, plus 14% per year. And in 2016, according to the European Parliament, Italy uses mediation at a rate 6 times higher than the rest of Europe. In 2021, during the COVID-19 pandemic, the Italian government was granted of funds by the European Union in order to restore the country and its economy. Among others, there was a commitment to reduce the length of civil trials by 40%. On March 2021, the Minister of Justice appointed the Commissione Luiso, whose proposals were released at the end of April, then submitted to Parliament. On November, the Law 206 was issued, delegation to the government to reform the civil proceeding and innovate the legislation on ADRs, mediation, assisted negotiation, and arbitration. The implementing decrees will be issued in 2022. As far as mediation is concerned, the main changes will be focused on more effectiveness of the mediation proceeding, increase of topics covered by mandatory mediation, more effectiveness of mediation ordered by the judge, involvement of the public administration, tax incentives, quality of training. Last but not least, increase in available funds, an expenditure of almost 4 million euro in 2022 and almost 60 million euros per year from 2023 is allowed. The focus on ODR is not relevant, provided that mediation and assisted negotiation procedures may be conducted, upon agreement of the parties, by telematic means, and that meetings may take place with remote connection. Legislation enacted in 2010 and rules approved during the pandemic also gave little attention to ODR. However, during the pandemic itself, the use of online proceedings grew enormously and is now an enduring trend. More effectiveness of the mediation proceeding. To encourage the personal participation of the parties, as well as effective discussion of the issues in dispute, by regulating the consequences of non-participation. Increase of the challenges covered by mandatory mediation. To date, according to Legislative Decree 28, the topics covered by mandatory mediations are condominium, property, wills and inheritance, family covenants and agreements, lease, loans, business and rents, medical malpractice damages, libel, insurance, banking and financial contracts. According to the Law 206, mandatory mediation will be applied also to contracts of partnership, consortium agreements, franchising, performance contracts, network agreements, supply agreements, personal partnership, subcontracting. Enhancement of court-appointed mediation. When mandatory mediation was introduced, the vast majority of judges considered it to be a child of a lesser God. However, the judiciary at a very slow pace began to realize the usefulness of the institute, and it's likely that mediation in Italy strengthened thanks to the judges. But there is plenty of room to grow. According to the rules in force now, the magistrate who settles a lawsuit in his role through a non-judicial solution, it is as if he did not work. The assessment of his/her productivity now is based on the number of issued judgments. If she spends time to analyze the mediability of the dispute, that makes a proposal for a solution, the parties reach an agreement and do not revert to court, the time she devoted to the case does not count for assessing her professionality. I repeat, according to the law now in force. According to the new law, the expertise of judges will be evaluated also on the basis of dispute settled by mediation. Involvement of the public administration. Officials representing the public administration generally do not attend mediation proceedings for fear of accounting liability. The new regulations will limit this liability to cases of fraudulent intent, and there will be a huge change in mindset, and it's very likely that it will take time for the future new rules to become effective. Tax incentives. The Legislative Decree 28 already provides all acts and documents relating to the mediation procedure are exempt from the registration tax and from all expenses, taxes or fees of any kind and nature. The record of the agreement is exempt of registration tax up to the value of euros 50,000. Otherwise, the tax is due for the exceeding value. The new rules should provide for the increase of the exception from the registration tax, the recognition of the tax credit proportional to the lawyer's fee for assisting the party in the mediation proceeding, the further recognition of a tax credit related to the court fees paid at the beginning of the judicial proceeding, following an agreement in mediation related to that dispute. Quality of training. According to my opinion, this should be the most important prerequisite for real development of mediation in Italy and elsewhere. In Italy, certified mediators are required to hold an BA degree in any subject or membership in a professional association and complete a 50-hour training course of theory and practice. But mediation is a multidisciplinary science. A 50-hour course is enough to inform, but not for professionals. Moreover, most trainers and trainees are lawyers. Therefore, lecturers mainly focus on civil procedure laws as applied to mediation. Will future legislation deal with these issues? Another very relevant innovation. Law Decree 118, converted into Law 147, enacted in 2021, introduced a new institute, the negotiated settlement for the solution of business crises. Mediation, therefore, entered into the rules of business crisis management in Italy, more precisely in contemporary Italy, because it was already part of the ius mercatorum in the Middle Ages, and above all, of the legislation of the Serenissima Republic of Venice. Problem. The vast majority of professionals who managed insolvency proceedings in Italy to date are generally familiar with adversarial techniques, which are underlying the legislation in force. It is likely that it will take time the innovation to be properly perceived. The challenge is open. Will we be able to cope with it? Many thanks for your attention.